right to an attorney, which I think you already know. You can hire an attorney, apply for public defender, or consult with an attorney before making any decision in this case. Option 3
Would
is...
that, I'm sorry, I apologize. Didn't mean to interrupt.
No, it's okay.
Would that be a continuance?
To get an attorney, yeah, since you don't have one today. Option 3 is you can take the offer in this case, which is driving while ability impaired. We would dismiss the DUI and the failure to stop at a stop sign, and you would plead guilty to the added charge of driving while ability impaired. It's 8 points against your driving privilege, a maximum of a $800 fine, up to 6 months in jail. We're asking for a period of probation with substance abuse treatment. And there's mandatory community service between 24 and 48 hours at the discretion of the court.
What is the substance?
So it's basically what they do is they look at the facts of this case, they look at any history you have. If you don't have any history, obviously there's nothing to consider, and then they make a recommendation on the level of treatment you may need.
You said what you were sponsoring or asking for would be substance, and I didn't quite catch the word.
Substance abuse evaluation and treatment.
Okay, so it's just an evaluation.
Well, it's an evaluation, and then the court would order you follow any recommended treatment.
So if I accept that offer, would I be able to appeal any of those things?
No, you'd be
So-
waiving your right to appeal.
So the judge at that point gets to decide what my penalty would be.
Correct.
And you're asking for
Probation, which is typical for a first offense.
probation plus...
The substance abuse, which is required under Colorado law.
That would be like random UAs, things of that nature.
Not necessarily, that'd be up to probation. The only thing that's required is the treatment aspect of it, not necessarily the random UAs. That'd be up to probation if they thought it was necessary in this case.
That's the sticking point. I just won a motion with the judge 2 weeks ago on the fact that I wasn't going to take mandatory evaluations while I certainly wasn't proven guilty, considering that the recent ruling was that medical patients under medical marijuana could still do it while they were convicted under, something that you're talking about. So I motioned to him that I should be waived of that, considering that people who are guilty have been waived of that. I'm innocent at this point. So as a medical patient, that's the sticking part.
Yeah, and there are certain provisions in place with regards to that. Probation would have to make a finding